Well, the imposition of the assessments are controlled by the governing documents. So there will be a board meeting that will have a budget for the next year, and included in the budget should be the imposition of the assessments. So the board of directors will set the amount of the maintenance assessments, and it also may very well depend on the governing documents on the frequency at which they would be billed, and if not, then the board can kind of decide how frequent an owner will be billed, so either monthly or quarterly. It's kind of rare, but I've seen some that have been billed annually as well. But usually it's either monthly or quarterly, and they're really due when they are imposed by the association. So as the owner, you're required to know when those are going to be billed, and if it's the first of the month, then you owe the first of the month. There's really no statutory grace period put in, and most of the governing documents of associations, there aren't grace periods put in. In some there are, but in most of them there aren't. And so it's really kind of up to the association and the board of directors to decide what, if any, grace period will be given. Now, there always is an argument in court that can be made for reasonableness. So if there is not a statutory requirement for a grace period, if there is not a requirement within the governing documents, and a person is one day late and the association decides that they're going to, go through these steps, a judge can always say that you didn't give enough time for reasonableness. The only issue with that is that's not going to happen very often, because before it ever gets to court, you have to have those notices that I talked about. So for an HOA, an owner would have at least 90 days to catch up. Now, they may have to pay some other fees along the way that have been incurred for the collection of it, but they're responsible for those. And in condominium, it's 30 days instead of the 90 days. You get a 30-day notice saying you're going to lien the property and you can foreclose on it, and then you can do that. So you're usually not going to have a case where you're going to be able to jump right into court without some type of time frame in a minimum of 30 days, say for a condo, and 90 for an HOA, where they would be able to pay back the monies, but they may have to pay additional monies, and that's kind of sometimes where the bone of contention comes in. Because if they're late for 3 or 4 days and then there's a late fee and interest tacked on, and the homeowner doesn't think that's right, and the association does, and guess who gets to decide? The judge. So it's always a good idea to find out from the management company, and a lot of times they will submit coupons and try and stay compliant with those payments and when those payments are due.